Hello and welcome to Seacrest Wardle's Premises Liability webinar series. Today we will be looking at insurance and indemnity issues. If you were with us last year, you might notice that at least the legal aspects of this have not changed much. These questions are controlled by settled rules of contract law that go back quite a few decades. The main case on indemnity remains the Michigan Supreme Court's 2014 decision in Miller-Davis. Since this is contract law, you might ask what this has to do with premises liability. These sort of contractual arrangements are not unique to premises liability, but we see them come up a lot, specifically in slip and fall claims involving snow and ice. Common example, snow removal contractors will agree to indemnify the property owner for any claims arising out of their work. They may also agree to name the property owner as an additional insured under their commercial general liability or CGL policy. Someone falls and gets hurt, they sue the property owner, and we're assigned the defense. At that point, we have to consider whether the snow removal contractor, or more often its insurer, should be covering the property owner's defense costs. These situations also come up in the context of apartment complexes and condominium associations when they have a property management company. The management company will, in some cases, agree to indemnify and provide insurance to the property owner. This relates to things like potholes or sidewalk cracks that the management company has agreed to repair or maintain. Property management company can in turn ask to be indemnified by subcontractors. And this can lead to some complicated upstream indemnity questions that we see more frequently in construction cases. It can still come up here. As you can see, we're talking about two different things that often appear alongside each other in these kind of contracts: an indemnity clause and an insurance clause. This is really a belt and suspenders approach to making sure that whoever is the one demanding to be indemnified at the outset of the relationship doesn't have to bear the expense of litigation rising out of whatever activity is in question. Before we go forward, there are two related words that I'll be using here that sound almost the same when spoken. You really got to see them on a printed page to see the distinction. There's indemnity, ending with a Y, and indemnity, ending with EE. Indemnity with a Y is the general concept of one party agreeing to cover the financial obligation of another. Indemnity with an EE refers specifically to the contracting party who is supposed to be indemnified. From time to time, I will emphasize the Y or the EE for clarity. There's a third term here, the indemnitor, which is the party who is supposedly agreeing to provide indemnification. If things are done correctly, the indemnity with a Y and insurance clauses will be redundant. The indemnity, EE, will be the named insured under the subcontractor or indemnitor CGL policy, and they get their defense and indemnity that way. The party being indemnified only needs to be defended and indemnified once per suit, and in many cases both clauses apply. So the contracting party's status as an additional insured renders the possibly more complicated contractual indemnity questions moot. Sometimes the indemnitor will drop the ball and not name the indemnity, an EE, on its policy, despite agreeing to do so in the contract. At that point, the indemnity EE's contractual claim, assuming they file suit, often becomes a liability claim under the indemnitor's CGL policy. The liability portion of these policies, you'll usually see a contract exclusion, but with an insured contract exception. And that insured contract phrase means is basically indemnity claims are covered. Now, in those scenarios, the indemnitor's carrier may find it more efficient to simply accept the tender and treat the party seeking to be indemnified as if it was an additional insured. This avoids setting the named insured up for a cross claim that the carrier would have to defend and that there might not be a defense to. In other words, if your insured is, for example, a snow removal contractor, sometimes it's clear, based on the relationship of the parties and the contract language, that indemnity is going to be owed one way or another. So it's better to avoid throwing a cross claim for indemnity on top of litigation expenses already being incurred in defense of the personal injury claim. But other times, either because of odd facts, odd contract language, or both, those kind of disputes simply can't be avoided. And this gets into our next slide. The party can owe indemnity with a Y without actually doing anything wrong. This is contract law, and the parties can fashion any sort of language they want, subject to a few exceptions, like the statute that we'll discuss in a few minutes. In the non-construction setting, the party can be indemnified for its own sole negligence, although it's rare and that intention has to be clearly stated in the contract. On the other hand, the ambiguities will be read against the party looking to be indemnified. So this discourages parties from trying to go too far in their indemnity language. In some cases, the indemnity language is worded in a way that third parties' mere claim of responsibility is enough to trigger the indemnity obligation, even when there's little or no evidence to back up the claim. Again, fault's not relevant here unless the contract expressly incorporates a fault standard. Sometimes they do, and in those cases, it can be tough to unravel the various defense and indemnity obligations until after a jury has allocated fault in the underlying personal injury case, which arguably undermines the purpose of indemnity because parties theoretically should be able to figure out who is paying whose defense at the outset. But sometimes the language compels that. An indemnity clause can go both ways. A contractor can say, I won't do this work unless you indemnify me. And the entity doing the hiring can say, I won't hire you for this work unless you indemnify me. Sometimes we'll see a battle of the forms, which can lead to questions about contract formation and who agreed to indemnify who, or whether there was an indemnity agreement at all. Other times they agree to indemnify each other, depending on which one is eventually found to be negligent. Although those clauses, again, often can't be sorted out until after there have been findings of fact in the underlying case. What this seems to me to be is a clumsy way of limiting indemnity to vicarious liability theories based on the other contracting party's conduct, while at the same time trying to rule out indemnity for a party's own negligence. I see this sort of language from time to time. It always seems to cause problems. But usually, the bargaining power between the two is such that it's obvious who's supposed to be getting indemnified. However, terms of the contract control, and the parties can agree to just about anything. Miller-Davis, the subject of this slide, this was a complicated case factually. It wasn't a premises liability case. It was a construction case relating to building a YMCA pool. The general contractor sued the roofing contractor for alleged defects in the roof. This was apparently quite a mess because the building was done in 1999, and the general contractor started complaining to the roofing contractor in 2003. Somehow the parties were still in front of the Michigan Supreme Court in 2014. So this gives you an idea of how these kinds of disputes can go. They can far outlast the underlying liability claim. But the importance of Miller-Davis to us today is that it lays out some simple rules for how indemnity clauses work. Contracting parties have broad discretion in negotiating the scope of these clauses. The only legal restriction upon indemnity is that you can't be indemnified for your own sole negligence in a construction contract. More on that later. Miller-Davis confirms that courts will try to give effect to the party's intention at the time they entered the contract, and that intent is determined by the language of the contract itself. Undefined terms will be given their plain and ordinary meaning. And a quote from the case, we avoid an interpretation that would render any portion of the contract nugatory, end quote. What that's trying to say is every word in the contract will be given some meaning. There's an assumption that people put words in there for a reason and that they're not just cut and pasted, which we all know happens. When an indemnity clause uses the terms all or any, it provides for the broadest possible obligation to indemnify. Miller-Davis goes on to talk about the fact that there cannot be any broader classification than the word all in its ordinary and natural meaning. It leaves no room for exceptions. The Supreme Court here also noted that the word claim is itself broad. And the claim is defined as the aggregate of operative facts giving rise to a right enforceable by a court, including any right to payment or an equitable remedy. This next slide relates to what we talked about before. We're emphasizing that this is a purely contractual relationship. It can be owed in situations that don't seem fair if the underlying allegations align with what the parties agreed to in the contract. Tenders of defense can be the subject of some confusion. It's really just a demand in writing that the other party cover your defense costs. There isn't a lot of case law about it because most of the time this is worked out behind the scenes early on in the litigation. Generally, it needs to be done before a complaint for contractual indemnity can be filed. Typically, it's sent to the other party to the contract as well as its insurer, if you know who their insurer is. If there is an insurance clause as well as an indemnity clause in the contract, I think it's best to ask for a copy of the subcontractor / indemnitor's deck page or the policy in the tender letter. Sometimes the indemnitor or CGL's policy won't name the indemnity specifically, but it'll include a contractor's blanket additional insured endorsement, something along those lines. Getting coverage as an additional insured can cut through a lot of the potentially ambiguous contractual indemnity language. So if your tender is denied or ignored, the next step as the party seeking to be indemnified is either a cross complaint, if the other side's already in the suit as a co-defendant, or a third party complaint if they're not in the suit. In certain situations, a separate action or arbitration might be required. Usually it's best to make the indemnity claim part of the underlying personal injury litigation via a cross or third party complaint. This makes it easier to do discovery and motions and make sure everyone's bound by whatever rulings come out of the trial court, and it makes settlement more likely. Sometimes they'll have a forum selection or arbitration clause in the contract, and that will require the indemnity claim to go down a separate track. If your insured receives a tender, there's both a legal and a practical analysis to perform. When this occurs after the premises liability has already started, conflicts of interest can arise for defense counsel. This is because defense counsel's client is at that point the insured, not the insurance carrier, and it's in the best interest of the insured for its own insurer to pick up the tender, since the potential cross claim then goes away. So what exactly is the issue here? It's a scenario that we've seen more than once here. The contractor and the property owner are both sued in a slip and fall. We get assigned the contractor. At some point in the litigation, the property owner tenders to the contractor based on an indemnity and or insurance clause in their contract. The contractor's defense counsel forwards that request to the adjuster, who asks defense counsel for a legal recommendation about whether to accept the tender. This is a problem because defense counsel's duty of zealous advocacy is to the contractor, who, as explained above, wants its insurer to accept the tender. So defense counsel can't objectively answer this in fairness to his or her client. Separate coverage counsel may be needed if it's not clear whether a defense is owed. So what do we look for when making a tender? Start, of course, with the contract. Third party's complaint is also relevant if you have one. Sometimes these analyses take place before litigation, but if you have a complaint, look at that as well. But depending on the contract terms, the mere existence of the claim can often be enough to trigger the duty, just regardless of what the specific theories are. As noted above, look for terms like any and all, and of course the word claim. That's what you want to see. Arising out of is a term of art that is important. There's a lot of case law about that phrase. It requires less of a direct nexus to the conduct than proximate cause. So if your client or your insured is entitled to be indemnified for any claims that arise out of the other party's work, that's about as broad as you can get. If there is an insurance requirement, focus on that for the reasons explained above. Again, you only need to get indemnified once, and the more thorny issues tend to come about when it relates to contractual indemnity. And that all goes away if you're an additional insured or treated like one. This next slide makes an important point. Although an indemnity contract can create a duty to defend in certain situations, it's not as broad as the duty to defend that we talk about in the liability coverage context. It's not the same duty that a liability carrier owes to their insured when sued. Under an insurance policy, the duty to defend is broader than the duty to pay any resulting judgment that might be entered. The duty to defend in the insurance contracts is triggered if on the face of the complaint, any count could possibly result in a covered loss. And the duty to defend applies to the whole suit. It can exist even when there's no duty to pay the underlying claim. An insurer will often provide a defense under a reservation of rights, even even when there would clearly be no coverage for the resulting judgment. But when your defense is being provided under an indemnity contract, these rules don't apply. The indemnity obligation under a contract is usually not as broad. It's usually coextensive with any duty to pay the actual claim. The next slide relates to some general rules of contract interpretation that we discussed above. This is underscored by Miller Davis, but it's repeated in many cases before and since. I would add to this slide, however, that the situation of the parties and the circumstances surrounding the contract formation only come into play if the contract is ambiguous. Otherwise, these things are parole or external evidence that isn't admissible if the contract is free of ambiguity. Put another way, courts are supposed to decide indemnity questions based on the four corners of the contract alone whenever possible. Again, if we're arguing about the meaning of terms in the contract, this is bad for the party looking to be indemnified. As noted above, these clauses are going to be read narrowly against the party looking to be indemnified. So if you're the party making the claim, you always want to argue that the contract is free of ambiguity, and if there's any key terms that are not defined, take the position it has a plain and ordinary meaning under dictionaries or other sources that isn't controversial. Now, as I alluded to above, there is a statute, MCL 691.991, that prohibits a party from being contractually indemnified for its own sole negligence. The statute only applies to construction contracts. The type of contracts we're usually dealing with here are not affected by it. And again, this sort of language, although it is permissible outside the construction context, is rare, and it has to be expressly spelled out. It's disfavored, but it doesn't violate public policy outside the construction setting. And I will add, I don't consider construction cases to be part of premises liability. That's why I'm drawing this distinction. Although there's some overlap, tort duties in the construction setting usually arise out of a general contractor's control over the work site. We're talking about the common work area doctrine here, and those duties are not based on a defendant's possession or control of the premises. So premises liability, most of the time this statute's not going to be relevant to us. So this wraps up our discussion of insurance and indemnity issues. Again, these kind of issues are usually quite simple and often resolved early on in the litigation. But in the wrong case, like Miller Davis, where they were still litigating on appeal 15 years later, sometimes these issues can blow up and cause parties to be in court years after the underlying liability claim is resolved. That's not good for anybody. Judges don't like it. Claim handlers don't like it. They obviously don't want to keep paying when the injured party's already been paid. So a little preparation early on can go a long ways in heading off these kind of disputes. Thank you, and have a good day.